Hello and welcome to the Zillow Group Fair Housing What You Need to Know webinar. My name is Maria and I am with Zillow Group Rentals, and I'll start with a few housekeeping tips. First off, you are in listen-only mode. If you have any technical issues at any point during the presentation, please contact the Technical Support Center at 866-678-2846. Be sure to reference our webcast title today, Fair Housing, What You Need to Know. Also, if you get cut off or if you can't stay for our whole presentation, our webinar is going to be recorded and sent out to every registrant. So don't worry if you have to miss part of it. Thank you to those of you who have sent questions ahead of time. We have well over 1,000 attendees dialed in today, so we won't be able to answer everyone's questions. We do, however, prepare questions ahead of time based on the questions we were sent in, and we'll do our best to follow up with questions after. Understand, though, that the sheer number of attendees makes it difficult for us to get to all of them. I'll introduce Lisa and Raquel in just a minute, but first I want to say a little more about Zillow Group Rentals. So what exactly is Zillow Group? Zillow Group Rentals encompasses three primary consumer rental brands. Those are Zillow, Trulia, and HotPads. With Zillow Rental Manager, you create just one listing and it gets posted to all three sites. Zillow Rental Manager makes it easy for you to post a listing. So, Zillow Group has a network rental, a site that's double of any other rental network. We have over 7 million qualified renters searching on our site. And a renter searching across Zillow Group is most likely to have a credit score in the 600 to 700 range, is ready to move in a month or sooner, and provides enough information up front for landlords to determine the next steps. You'll save time when you know which contacts are the most qualified. Also, don't forget to check out our Rental Resource Center. It's an invaluable center to old and new landlord and property managers of all types. Our Resource Center includes information for first-time landlords, as well as forms and additional, more in-depth articles for those of you who are more advanced. Also, if you haven't heard, you can also now add a rental video walkthrough to your rental listing. All you need to do is download the Zillow Rental Manager app to your Android or iPhone, and then you can select a listing and take your video. Adding a video is so easy, and it saves time, and only the most interested renters, after seeing your video, will be contacting you for an additional showing. Don't forget, this rental video walkthrough is for units, 50 units or less. All right. Once again, this webinar is being recorded, and now I'll introduce our first presenter, Raquel Russell. Raquel is the Director of Government Relations and Public Affairs at Zillow Group. Her work creates partnerships for Zillow Group with government and non-government organizations with the ultimate goal of empowering consumers with data, inspiration, and knowledge around the place that they call home. Previously, she led President Obama's Office of Urban Affairs and Economic Mobility, where she focused on numerous issues, including affordable housing, as well as community and economic development. Raquel received her Juris Doctor from George Washington University of Law. Raquel, I'll hand it over to you.
Thanks, Maria. I'm so glad to be here and happy to have everyone on the call and the webinar. Hopefully, we will cover everything that you need to know about fair housing in the next hour or so. As many of you probably do know, April is Fair Housing Month, and we at Zillow Group are helping to spread the word about the importance of fair housing. That includes helping landlords and property managers who use Zillow Group's platforms with resources for understanding fair housing laws. I'm excited to introduce and welcome Lisa Rice, the Executive Vice President of the National Fair Housing Alliance today. She oversees communications, resource development, public policy, and enforcement initiatives for the National Fair Housing Alliance, and is responsible for helping to achieve the organization's goal of addressing the crisis of segregation. Lisa has provided extensive fair housing and fair lending training to many different audiences, including consumers, government agencies, private businesses, and nonprofit organizations. So we're really excited to have Lisa here with us today. Before Lisa and I get into our conversation today, I'd like to send a special thank you to Harry Kelly of the law firm Nixon Peabody. Harry was so instrumental in helping us prepare for this presentation and making sure the information we are sharing with you today is up to date and accurate. But I do have one major caveat for our listeners before we dive into today's topic. Today's webinar is only a primer when it comes to fair housing laws. Nothing in today's webinar should be construed as legal advice. We encourage each of you to contact legal counsel before taking any action or making any decision. Everything we share today is intended only for informational purposes, but we hope that it's going to be helpful and a great starting point as you learn a little bit more about fair housing laws. Lisa, thank you so much for being here, and a special thank you to the National Fair Housing Alliance, also known as NAFA, for being such a great partner throughout Fair Housing Month. Your organization was created to be the voice for fair housing. Will you start by telling us what fair housing means to NAFA and why it matters?
Raquel, thank you so much for inviting me. I'm so happy to be here. The National Fair Housing Alliance is the nation's only national nonprofit organization that is dedicated solely to eliminating all forms of housing discrimination and expanding equal housing opportunities. We engage in education, outreach, public policy, advocacy, research, community development, and enforcement initiatives, and we do all of that to advance fair housing throughout the United States. And Raquel, what we do is so incredibly important because in America, place matters. Where you live determines almost everything about you, from how long you're going to live, to the types of schools your children will attend, to even how much money you're going to earn in your lifetime. And that is because place is so tied to opportunity. And at the National Fair Housing Alliance, we're working to ensure that every neighborhood and every community has the opportunities, the amenities, and the services that are necessary for people to enjoy full and complete lives.
So one of the challenges, Lisa, that I know with housing discrimination is underreporting, right? I know that some researchers outside of government have done some work to extrapolate the instances of housing discrimination. So how big of a problem is housing discrimination in America today?
Well, Raquel, unfortunately, housing discrimination is a very large problem because oftentimes people don't know that it's happening. Housing discrimination is the silent disabler because it is so clandestine and so hidden. We estimate that there are over 4 million instances of housing discrimination that occur every year, but only a very, very small fraction of those cases actually get reported.
Wow. So let's kind of get into the nitty-gritty here. Who does the Fair Housing Act protect?
So there are 7 protected classes under the Fair Housing Act: race, color, national origin, religion, gender, familial status, and disability. And I need to place a footnote here because the actual statute does not use the word disability. It uses the H word.
Got it.
But in the disability community, the H word is akin to the N word.
Got it.
Right? And so we do not ever use the H word. We use the disability word.
Got it. So one of the reasons why, we said at the top of the webinar that we want to make sure that our listeners, landlords, and property managers contact outside legal counsel is because we're going to talk a lot today about the federal law, but local fair housing laws also vary state by state. So how should listeners figure out their state and local laws?
So one of the easiest things that you can do is if your state has a state statute, you can go to your state AG site or do some searches on
AG, Attorney General.
Attorney General. I'm sorry, the acronyms, right? I'm sorry. And you might even be able to Google it, right? And what you want to do is look at your state statute, because we do have state laws that cover beyond protected classes beyond what the federal statute covers. So we have veteran status. Some state laws cover age. Some state laws cover source of income or sexual orientation. Here in the District of Columbia, political affiliation is a protected class, and that makes sense.
Apropos. Great. So for our listeners, these are the topics on slide 6 that we're going to be covering today at a very high level. But as we just learned from Lisa, state and local laws may be different for you, so be sure to contact legal counsel or the state attorney general before taking or the state attorney general's website and learn more information about what's happening in your state and local markets before taking any action or making any decision. But today we'll cover disparate impact first up, and then we'll talk about things that landlords and property managers often are dealing with: criminal record screening, limited English proficiency, source of income, advertising and steering, and then finally we'll provide you with a list of resources to kind of get you started following this webinar if you wanted more information. So first up is disparate impact. And Lisa, we're going to focus on disparate impact, but before we go there, we should probably talk a little bit about disparate treatment. So disparate treatment and disparate impact are both important for landlords and property managers to understand, but can you talk to us a little bit about the difference between the two and what each of them means?
Absolutely. I'd be happy to do that. Disparate treatment, I'd like to think of disparate treatment as an inconsistent application of policies or practices. So you have policies, you have practices, you have procedures or protocols that you have put in place, and you don't follow them religiously, right? So you are carrying out the policies and practices in an inconsistent fashion. Disparate treatment is equatable to unequal treatment. So you're treating people differently, and the law says that's discrimination if you treat people differently based on their membership in a protected class.
So one of those 7 classes, or from a state and local perspective, additional classes that may be protected under state and local laws.
Exactly.
Great.
Disparate treatment is disparate impact or discriminatory effect, and we do use those two words interchangeably. Disparate impact is the reverse or the flip of that. You have a policy or a procedure, you apply it to every single person the same across the board. You never ever deviate. But the application of that policy or practice, which appears to be facially neutral, when you apply it, it has a discriminatory effect or a disparate negative impact on a class that is protected under the Fair Housing Act.
Got it. So can you give us a little bit more on disparate impact? Can you give me an example of how a landlord might unintentionally do something that would be considered to have a disparate impact on a protected class?
Of course. Let me give you this example. Several years ago, I worked with a community development organization in the state of Ohio who had built a very large development of both rental housing and housing for home ownership. So there were 2 sides of the development. One side was rental. The other side contained houses for sale. The company adopted a policy, and that policy stated that only people who were gainfully employed could rent the housing units or be eligible to purchase the housing units that were for sale. And unfortunately, this type of a policy had a disparate impact or a discriminatory effect against people with disabilities who have much higher unemployment rates than the general population. So we worked with the housing management company to first understand why they had this rule in place. And as it turns out, what they were trying to do is ensure that folks would be able to pay the rent.
Makes sense.
So, exactly. So what we helped them to do was to develop a procedure to determine if residents would have sufficient income, be it via a job or Social Security income, to be able to afford the unit. Because as you well know, Raquel, there are lots of folks who have jobs who don't pay their rent or don't pay their mortgages.
Absolutely.
So having a job was not going to get them to their end goal. What they really wanted to know is, do you have sufficient income to live here? And in the places where you've lived before, did you pay your rent on time?
Got it. So the policy was for everybody. It was, everyone had, that policy applied to everyone, but it disparately negatively impacted a certain class that's protected under the Fair Housing Act.
Exactly.
Got it. And you help them reach their objective, but through a different policy.
Exactly.
Which is great. So it feels like disparate treatment is fairly straightforward, right? You have a policy, but you're not treating everyone equally. It's unequal treatment. But disparate impact, especially for a landlord or property manager, it feels a bit more complicated. And if I'm a landlord and I'm totally unaware that something I'm doing may have an unintended impact on a protected class, how does disparate impact get proven or disproven? Can you walk us through the steps? And I know there's a 3-step approach. Can you walk us through and maybe give another example of how this would work?
Absolutely. So stay with me. I'm asking everybody on the phone, stay with me, because I'm going to take you on what I call the disparate impact journey.
Got it.
So as you accurately mentioned, Raquel, there are 3 steps. There are 3 prongs. We call them 3 prongs. So the first prong or the first step is that you have a policy or a practice that on its face is neutral. But the application of that policy or that practice has a disparate negative impact on a protected class, or it has a segregative effect in the community. Okay, so that's the first step. Once the complainant can show that that policy or practice has a negative effect, and usually what has to happen is the defendant or the complainant has to conduct some type of a statistical analysis to show that there's a discriminatory
And the complainant could be the tenant itself, it could be an organization, it could be a government entity, but the claimant could be more than just a tenant.
It could be a group of landlords, and I'll talk about a case like that in just a minute. It could be landlords. It could be real estate agents.
Got it.
So anybody who alleges that they've been aggrieved under the law can bring a claim.
Great.
So you have to conduct a statistical analysis that shows there's a discriminatory effect.
So that first step it's a pretty big burden to reach.
It's a big burden.
Okay.
It's a huge burden, and in some cases, Raquel, it's a very costly burden.
Absolutely.
Conducting a statistical analysis is no small feat, right? You got to hire an economist or a statistician, right? So once you've proven that, the second step shifts the burden to the landlord, right, or the housing provider. So it could be a lender, it could be an apartment association, it could be a real estate company, it could be an insurance company.
Got it.
But the second stage or the second step, the burden shifts to the housing provider to show that the policy at question is there for a non-discriminatory, legally sufficient business reason.
Okay.
So you've got to show a non-discriminatory business justification for the existence of that policy or that rule.
Yep.
Now, once the landlord shows that or proves that, then the third step or the third prong, the burden shifts then back to the complainant to show that there actually is a less discriminatory reason or a less discriminatory way to achieve the business goals. So, Raquel, let me take you back to the example that I gave before. Our community development organization had a policy saying everybody has to be gainfully employed. So we conducted a statistical analysis. We used statisticians based on census data, and we showed that that policy had a discriminatory effect
on
people with disabilities. Then the burden shifts to the community development organization who said, we have a legitimate business justification. We want to make sure everybody can pay their rent.
Absolutely.
And then the burden shifted back to us to say, you know what? there's a less discriminatory alternative that will actually help you better meet those business goals.
Got it. That's great. Thank you for the journey. I think I understand, and hopefully all of our listeners do as well. But we've given our listeners a lot to think about just on this issue of disparate impact. So, what are some of the best practices for landlords and property managers, Lisa, when you're thinking about disparate impact?
Absolutely. So first of all, keep in mind that disparate impact issues arise when the benefit is withheld. So you're denying a person an opportunity, you're taking away a benefit from a person, and that's typically when a claim of disparate impact will arise. The second thing we tell folks is you want to identify a legitimate, non-discriminatory reason for having that business practice. Mm-hmm. And then you want to examine your true intent. What is the real reason you're trying to put this policy in place? What is your real goal here?
Yeah.
And examine that goal and make sure that you're employing the best policy to help you reach your legitimate business goal.
Got it. So now let's apply disparate impact to a pretty regular practice in the rental space, which is criminal record screening. HUD, the U.S. Department of Housing and Urban Development, put out guidance saying, was it a couple years ago now? Put out guidance a couple years ago saying that conducting background checks on prospective tenants may, and that may is important, may have a disparate impact on people of color. So can you, using this three-step approach, can you walk us through how HUD was thinking about criminal record screening as it relates to disparate impact?
Sure, absolutely. So again, a lot here hinges on what type of policy you might be putting in place and how that policy is going to affect different groups of people. So for example, we know that African Americans and Latinos are stopped by the police and frisked by the police and arrested by the police at much higher rates than their white counterparts. And as a result, these groups face much higher rates of incarceration. So let me give you a couple of examples that have recently arisen. In response to the opiate epidemic that is facing so many communities across the country, we've had a number of sheriffs, even in the community where I live in Maryland. Mm-hmm. We've had a number of sheriffs in counties throughout Maryland, counties throughout states like Ohio, Indiana, who have said that if they catch a person using opiates, they're not going to treat those people as criminals. In other words, they're not going to arrest those folks. Yeah. They're going to treat these people like they need medical attention, and they're going to put them through rehab programs. Now, we don't see the same kind of announcements for people who use crack cocaine. And we know that the opiate epidemic disproportionately affects whites, while conversely, the crack cocaine epidemic disproportionately affects African Americans and Latinos. So you have the same criminal activity, which is the illicit use of drugs, but you have two different policies that are being employed in terms of treating people who are involved in those two illegal activities. So as a result, you automatically know right there you're going to have disparities in terms of who's getting matriculated through the criminal justice system and who's not being picked up.
And just even in that example, and as you were talking, I was like, this is so far outside of the scope of what landlords and property managers have to deal with. It's almost like these disparities that are happening in other aspects of life, are now coming into their backyard and potentially impacting their day-to-day life and, them being able to find tenants for their property.
Exactly. So you're absolutely right, Raquel. Landlords have nothing to say, right? They have no authority over how the local sheriff is going to handle people who are using opiates versus, people who are using crack cocaine, or what the local police department is doing, or what the ATF is doing, or the DEA, right? Yeah. But it's still going to impact them, because what happens is people of color are going to have those criminal records, whereas white people are less likely to have those criminal records. So let me give you another example. And this is an area where there have been a gazillion studies done all across the United States. We know that whites, blacks, and Latinos use marijuana to the same degree. Mm-hmm. There's same rates of usage. Okay. But African Americans are arrested and convicted at a rate that is 6 times higher than the rate for white Americans. And this is largely because communities of color are more heavily policed than white communities. So again, same level of usage, but very different outcomes when it comes to rates of incarceration. And so what that tells us, Raquel, is that just looking at criminal records is not going to give you the whole picture about a person and what they might be involved in. So looking at criminal records can give you one picture, but it's not going to give you the whole picture. So what we do is we advise landlords to use criminal records as the very last component of their screening process. The first thing you should be doing is looking at all of the other qualification and eligibility criteria, right? So a better way to go is to assess the person individually. Look at, do they meet the income qualifications? You know, will they be violating any occupancy standards? What is their payment history when it comes to paying their rent? What are their previous landlords saying about their activity and their tenancy in their previous situations? And then after you've completed all of your other screening, then use the criminal background screening as the last process. We do think that landlords should be looking at people individually rather than, for example, implementing some type of blatant zero across-the-board blanket zero tolerance policy that will knock out so many people.
Yeah. And this is one of those areas, disparate impact in and of itself is a complicated concept, right, to know whether you're actually, you know, whether to prove or disprove, right, because the 3-step approach is, like you said, it's a journey that you have to go on. Criminal records is one of those areas where HUD has said that it could, not always, it's not like cut and dry, but it could be proven that a criminal record screening does violate or does create disparate impact. So you just talked a little bit about some of the best practices for landlords and property managers when thinking about disparate impact as it relates to criminal background checks. We also know that, you know, HUD-assisted housing, which, you know, most of our listeners are not connected to HUD-assisted housing, but some of them may accept Section 8 vouchers, right? So some of our listeners may be Section 8 landlords. And we know that, you know, HUD standard practice for HUD-assisted housing and Section 8 landlords is to do a criminal record screening. So there seems to be a little bit of tension between what HUD's guidance says and what, you know, HUD's properties, whether it be Section 8 landlords or their HUD-assisted properties, would do around criminal record screening. So how do you juxtapose those two things?
Exactly, right?
Yeah.
It's very confusing.
Yeah.
And we have reached out to HUD to ask for clarification because what complicates this issue even more, Raquel, is that HUD has issued guidance since the 1990s on the usage of criminal records and what people should be doing and how they should be treating folks who have criminal records, and that guidance has changed throughout the years, right? What has happened is in recent years, because the criminal justice issue has gotten so out of hand, I mean, I don't know if our listeners know, but the United States has the highest rates of incarceration across the industrialized world.
Wow.
I mean, when you compare us to any other nation, we have by far the highest rates of incarceration.
Any other comparable nation, like
Yes, exactly, exactly. Much higher. We outstrip every other industrialized nation. So it's
a list you don't want to be first on.
We don't want to be first on this list, but we are, unfortunately, in the United States, right? And it can hold so many people back. And so what the federal government is trying to do is give people an opportunity to come back into society and to be productive citizens in our society. So HUD's recent guidance says basically what I just described for you before. And when we have reached out to HUD and said, okay, now how do you apply this new guidance that you just issued vis-a-vis all of the other guidances that you've issued before since the 1990s? And they've said the most recent guidance, of course, takes precedent. So look at the most recent guidance first. And then, if you're accepting Section 8 tenants or housing choice voucher tenants, look at the other guidances and follow them. Don't not follow the guidance. But, go back to what I just described. Look at everything else first.
Those other factors, income, well, you know how their rent, but like what their previous landlord said, look at those other factors before going to criminal record screening. Great. So moving on to our next topic, let's talk a little bit about limited English proficiency and source of income. And let's start off with limited English proficiency guidance. So what does this term mean, limited English proficiency, a term that I clearly can't say properly, and how does it relate to fair housing?
We all are English challenged.
I mean, yes, clearly proficiency is my word that I'm challenged on.
Limited English proficiency means a person who is either non-English speaking or they do not use English as their first language. So it doesn't mean that a person doesn't speak English at all. It just may mean that the person doesn't use English as a first language. And so they are limited to some degree in their ability to read, write, or understand English.
Got it. And so, HUD put out this guidance in September of 2016 warning that discrimination against limited English proficiency persons may violate the Fair Housing Act. And they've talked a little bit about both intentional and unintentional disparate impact. So one of the questions that popped out to me as we were preparing for this is whether HUD's guidance imposes a new duty to provide translated documents or interpretation services, because that would seem like it would be overly burdensome for landlords and property managers to do so. So what's the National Fair Housing Alliance's thoughts on that, or your thoughts on this?
That's a great question, Raquel. So let me just make it clear first that HUD's guidance does not place any type of mandate on landlords to require them to provide documents in multiple languages. Now, we know that there are some landlords who do that because they are providing housing in neighborhoods or communities where they have very high levels of non-English speaking people. So in areas where you have high concentrations of people who speak Vietnamese or who speak Spanish, we do see quite often landlords will provide materials in multiple languages. But it can be an expensive thing to do. So if you're a smaller landlord, you're not likely to have the resources to develop those kinds of forms. But no, the rule does not require you to do that.
Got it. Okay. So let's touch briefly also on source of income. What do we mean by source of income, and how does this apply or how should landlords apply this in their daily practice?
This is an important issue to touch upon because,
we talked about it a little bit earlier.
As we referenced earlier, there are lots of states that have source of income as a protected class. And it just simply means how you receive legitimate income into your household. So it could be your source of income might stem from alimony payments or child support payments or a housing choice voucher, SSI payments. So any legitimate income that is coming into your house would fit the characteristic of source of income.
And as this slide says, under disparate impact, it gives like an example similar to the one from the Community Development Organization back in Ohio that you worked with, where persons with disabilities disproportionately receive rental assistance, so failure to accept Section 8 or SSI could have a disparate impact on that demographic. So something for landlords and property managers to be aware of as they're looking to find tenants for their properties.
Exactly, and this arises in the lending space, where you might have a lender who is refusing to accept SSI income because the Social Security Administration will not issue a letter saying that this income is likely to continue for 3 years.
Oh, interesting. I didn't realize that. Yeah, okay.
So there have been a number of recent cases along those lines.
Got it. So let's move into an area most landlords are quite familiar with, advertising and marketing a property for rent, and the policies
My favorite subject.
and the policies that are put in place for tenants to abide by once they become tenants. So, Lisa, advertising a home or apartment for rent is an area where landlords can quickly fall into violating fair housing laws just by the language they choose. Can you share with us, the listeners especially, what landlords need to watch out for and how to create an ad that is compliant with fair housing laws?
Absolutely. I said earlier, and I was not joking, this is my favorite subject. I love advertising and marketing. I love this area. I actually help manage the advertising and marketing campaigns for the National Fair Housing Alliance. Little shameless plug there. We'll tell you how to get those ads a little bit later on. But so what you want to do is you want to advertise your unit. You want to advertise your services. You don't want to advertise the type of people that you want to live in the unit or the complex.
Got it.
So you're going to make sure that your advertising is descriptive of the amenities and the benefits of the housing unit or the complex that you're providing. So you're talking about how beautiful it is. It has high ceilings. You're talking about the wainscoting. You're talking about the hardwood floors. You're talking
I want to live there.
I was going to say, don't you want to live here?
I do.
You're talking about the oversized bedrooms and things of that nature, right? I want this house. So that's what you're trying to do. You're not trying to say we want people with no children, or we want professionals, or we want young professionals. That's not what you're trying to do. We strongly encourage people to use the Fair Housing logo and slogan, and you see it right up there on the screen. It's that house with the equal sign in it. You want to put that in all of your ads. You want to use the words equal housing opportunity in all of your ads to let people know that you're going to be abiding by the fair housing laws. Now, one interesting thing that most people don't know about the Fair Housing Act, the Fair Housing Act says that any notice, any statement, written or issued verbally, is an advertisement. So what you say, the words coming out of your mouth, can be an advertisement.
Oh, interesting.
Yes.
Well, that is a good segue into our next slide, our next topic, which is around steering. When a landlord tries to attract or deter a potential tenant into or away from a certain neighborhood or complex or unit based on a protected class. So, this I think correlates very closely with advertising and what you just said with regards to what constitutes advertising. But can you provide some examples of what steering could look like in the rental space?
Certainly. Steering is not necessarily an outright refusal to rent, but it consists of efforts to deprive a person of a housing opportunity based on the location or where that person would be living. So steering, for example, people with disabilities away from one particular part of a complex or one building in a complex to another building.
Yeah.
Or steering families with children away from one building to another building in the complex. I worked on a couple of cases where all families with children were put in one building and all single people were put in another building. Yeah, you can't do that.
And one example that we give here also is, like, suggesting to the family with children a ground floor unit versus a top floor unit with a balcony because you're concerned about the kid potentially, hurting themselves or falling off the balcony.
That's a perfect example.
Okay, interesting. Okay. Mm-hmm. And so what are some of the things that landlords can do to make sure they're not staring people inadvertently with their advertising practices, whether that's verbally or in print?
So you want to make sure that you're giving truthful information to tenants. You want to make sure that you're not giving any misinformation about the availability of a unit. If a tenant is coming and asking for a 2-bedroom apartment, you tell them about all the 2-bedroom apartments that are available, and you let that tenant make the decision about where they want to live. You're giving truthful information about the amenities and the services that come along with renting that facility so that people can make an informed decision based on all of the knowledge. So you don't want to be giving, one set of potential tenants all the information, and then another set of potential tenants, just half the information.
And even if you're thinking you're doing it just to be helpful,
no,
don't do it.
No.
Okay, that's what I'm hearing. That's what I'm hearing. Great. Okay, so last topic for today is tenant policies. In addition to requiring that, their tenants be law-abiding, most landlords will also have their own set of rules or policies that they set for various reasons, whether it's to protect the property or create a safe environment for those who live there. I'm a renter myself, and my apartment just sent out another email reminding those with dogs to keep the dogs on leashes, that even though you think your dog is friendly, not everyone knows your dog, and so you need to put your dog on a leash. And they do that so that the other tenants feel safe and comfortable in our apartment, right? So tenant policies are a pretty common thing. What are a landlord's rights when it comes to making rules and policies, and what should they avoid?
So every landlord has a right to implement the rules that they believe will make the facility better for all of the tenants, recognizing that the landlord wants to protect her property, and she wants to make sure, that people are not going to be violating the property, and that they're going to be treating the other tenants
totally,
in an appropriate fashion. So rules need to be first fair, and they need to be applied to everybody. So you don't want to devise rules that are only applicable for a subset of
families with children,
like families with children, or like non-English speaking people, right? And you never want to highlight a protected class under the Fair Housing Act unless there is a legitimate safety reason. Okay. So, for example, a policy that I think is perfectly fine is to say no children under the age of 12 can be at the pool unaccompanied by an adult.
Makes sense.
That makes sense, right? Because you're looking out for the safety of the child. And you might even have some state or local laws that speak to that.
Requires you to do that.
Yeah, exactly.
And another thing on the state requirement piece is occupancy standards, which I know you alluded to earlier.
Exactly.
Can you talk a little bit about that, too?
Certainly. And so this is an area where a lot of landlords are concerned about, and what we tell landlords is to follow your local occupancy ordinance. So find out what that is, consult an attorney if you don't understand what it means, and then follow whatever that local occupancy ordinance is.
Great. So before we go to the questions and do some questions and answers, we wanted to provide our listeners with a list of resources available to landlords and property managers to help them ensure they are complying with federal and local fair housing laws. So this list is by no means exhaustive, but it is a good starting point for our listeners today. And Lisa, is there anything you want to highlight for our listeners that's on this slide?
Absolutely. Check out our resources page. So if you go to our website, nationalfairhousing.org, you'll see all kinds of information on there. And then we have a special tab for fair housing resources. And if you click on that tab, you can actually get downloadable PSAs, public service announcements. We have brochures. We have all kinds of print material. We have television ads. We have radio ads. So we have lots of resources for people to use.
And National Fair Housing Alliance is a national organization, but it's a network organization. So in many of our listeners' states and localities, there may be a local fair housing organization, and they can find that information as well at the nationalfairhousing.org website.
Exactly, and
Great.
we encourage folks to partner with their local fair housing organizations.
Great. So, Lisa, thank you for sharing all of this important information with our listeners. We covered so much today, and I want to encourage our listeners to contact their local fair housing organizations or a legal professional who knows your market way better than we do here at the national level before you take any action or make decisions. But for now, I think it's time to open up for questions from our listeners. But before we do that, I would also like to welcome Morgan Williams, who is General Counsel for the National Fair Housing Alliance. He has been with NAFA, the National Fair Housing Alliance, for more than 5 years and has over a decade of fair housing experience. Morgan and Lisa will tag team for our Q&A portion. So, Morgan, welcome to the call.
Thanks so much.
So we've got a few questions that have already come in, and I know there's other questions that are coming in live as well, so we're going to try to get to as many as we can in the time that we have allotted. But first up for Morgan and Lisa, if you don't have a pet policy, how do you deal with service and assistance animals? What documentation do they need to have, and what if they acquire one after moving in? So, a lot of apartments don't allow pets. What do you do when you have a potential tenant or a tenant who has a service or assisted animal?
That's a great question, and I'm going to lob that over to Morgan.
All right, Morgan. First one's up for you.
Thanks so much, Lisa. And thanks for the question. It's a question that involves a lot of information, and I will give a very cursory overview. It's, in fact, a question that itself could be an entire webinar presentation and deals with an important area of rights under the Fair Housing Act. The Fair Housing Act prohibits discrimination and treating someone differently on the basis of any protected class, but when the Act was amended in 1988 to add, among other things, the protections for people with disabilities, there are certain affirmative rights that were granted to people with disabilities, which is a little bit confusing for housing providers because on the one hand, you're not supposed to treat someone differently on the basis of their disability, but in the context of these affirmative rights, there are actually instances where you're specifically supposed to treat someone differently on the basis of their disability. So it admittedly can get a little bit confusing. But what these affirmative rights entail are things like what are called reasonable accommodations or reasonable modifications, and in the case of new multifamily development, certain design and construction standards of the sort that we would typically think of in regards to accessibility requirements of under the ADA in the public accommodation context. Specifically, in regards to reasonable accommodations, it's required that housing providers allow people with disabilities to grant waivers of their rules or policies to allow a person with a disability to enjoy a dwelling unit. And a very common form of reasonable accommodation request is a request regarding the permission to have an assistance animal in the context of a housing provider who has a no pet policy or otherwise has pet-related fees. An assistance animal is an animal that provides some sort of therapeutic value for a person with a disability. It could be someone that provides guidance to someone who's blind or deaf, or it could be someone an animal that provides a therapeutic value, emotional support to someone with a disability that requires such therapeutic assistance. And in such instances, a housing provider must change their policy to allow someone with an assistance animal to live to have the animal, usually a dog or a cat, but it could be some other form of animal that provides its therapeutic value. There are a couple of great resources available One is HUD and the Department of Justice issued a joint statement on reasonable accommodation requests. And if you simply Google HUD and DOJ joint statement reasonable accommodations, the first thing that comes up is this memorandum that provides a lot of overview. Furthermore, HUD, yes?
No, go ahead, Morgan.
Oh, great. Furthermore, HUD issued in 2013 a specific memo that details service animals and assistance animals for people with disabilities in the housing context, in housing and in the HUD-funded program, excuse me. And this provides specific guidance on what a housing provider can ask of a tenant when they have an assistance animal. And it essentially says the housing provider can ask two things. Does the person seeking to use and live to use and live with the animal have a disability? And again, that's a physical or mental impairment that substantially limits one or more major life activity. And two, does the person making the request have a disability-related need for an assistance animal? And if the answer is no to either of those questions, then the accommodation request may be denied. But if the answer to the question, both of those questions is yes, then there's an affirmative duty that the housing provider has to grant the assistance animal. Now, there's a couple of exceptions to that, and I can get into them in more detail, but I would just say that this memo, and I think there's probably some way for us to send this to all of the participants, both the HUD-DOJ joint statement as well as the specific guidance regarding servants and assistance animals to the participants.
Great.
And I'll turn it over.
That's a lot of. You were right, Morgan. That was. There's a lot of information there. One of the other questions that we got. Thank you so much, Morgan. One of the other questions we got was, do maintenance and caretaker workers need to be concerned about the Fair Housing Act?
Absolutely. In fact, when we conduct trainings for apartment complexes, we require every single individual, including maintenance workers and caretakers, to be a part of the Fair Housing training, because under the Fair Housing Act, there's this thing called non-delegability, which means that anyone who is working for you, if you are an apartment manager or a landlord and you hire someone to perform any kind of work on your ground, whatever that person does, you are liable for their actions. And if they violate the Fair Housing Act, you're liable for that. And unfortunately, I'm sad to say, Raquel, we get lots of complaints of housing discrimination where a maintenance person or a caretaker has done something that they should not have done, and the landlord is held responsible.
Great question. So one of the other questions, we were talking about this a little bit earlier, is around
real quick on in regards to that last question, this is Morgan. I just wanted to indicate that there's a great resource for more information on that. And it's actually in the context of a September 2016 HUD rule that was issued that details protections for victims of harassment and survivors of domestic violence.
Oh, interesting.
The rule that details the rights for victims of harassment actually goes into a great detail on agency liability under the Fair Housing Act and how HUD interprets that, and really interprets the agency of housing providers very broadly to encompass the acts of their employees, and there's good guidance and detail about their application of that in that guidance.
Great. So students, we had a lot of questions around students. Leave the students alone! How do landlords protect themselves when working with young tenants, such as college students or fresh graduates that haven't built any credit history or or things of that nature. But also just, quite frankly, are students a protected class was another part of that question that we got, You have a son that is of college age. I was a college student not so long ago. I feel like I've grown up since then. It's a different mindset. So talk to us a little bit about that student perspective, both on how you work with a student who doesn't have the kind of credit history, but also that question around, are students a protected class?
Yeah, no, this is a very interesting area, and the thing that I would like to say to all of our housing providers out there is remember that student could be your child, and they're all saying, that's why I don't want them living in my complex.
Yeah.
So at the federal level, just the category of student is not a protected class under the Fair Housing Act. But you might have some states and local jurisdictions that do protect students, and so you want to make sure that you know that. Or you might have age as a protected class, and that could come into play, and that would protect young folks and students. If you are dealing with a student who has no history and they have no credit history, they've never rented before, you can require that student to have a cosigner.
Okay.
And oftentimes that is the case, and that's what happens, is the parents will cosign or an older sibling will cosign for the student who has no previous history. But there again, you have to be consistent in the application of that policy or practice.
Mm-hmm. That makes sense. And so with regards to, again, this is another example of state and local laws can be very different from the federal law, and why it's important for our listeners to reach out to legal professionals in their local market, because the laws may very well be different.
Exactly.
Before making decisions or taking any action. So this is an interesting question, and we kind of alluded to this a little bit earlier, but wanted to spend some time on it. For our listeners out there, we got a lot of questions around income requirements. So how does one consider income requirements, such as income to be 3 times the rent amount when looking at Section 8 applicants? So it's a little bit of convergence of two of the issues that we were talking about earlier.
Right.
How does that work?
So this might come up as a disparate impact issue, and it's an example of a type of a policy that a landlord can put into place that could potentially pose a disparate impact, but also at the same time might be reasonable. So, for example, we have lots of landlords who say you have to earn 3 times the monthly rent in terms of your monthly income in order to be eligible.
Yep. And
that typically has been borne out to be a legitimate practice, right? Because you want to make sure that the person can afford the rent. Now, when we start getting into policies that are 4 times the rent or 5 times the rent, now you're reaching a little bit.
But to your point earlier,
And
to your point earlier, there's been so much research and studies from economists on the housing side saying basically you shouldn't spend more than about 30% of your income on your rent or your mortgage, whatever the case may be. So hence why that's such a legitimate practice, because the research has been borne out on the housing economic side.
Exactly. We don't have research, to your point, Raquel, that says you shouldn't spend more than 20% or 25% of your income on housing expenses. Okay. And so then the question becomes, well, what about a person who has a housing choice voucher or a Section 8 voucher? That person may not be making, in terms of their monthly income, 3 times the rent, but they have the housing choice voucher. And so in those instances, you would not be applying the 3 times the monthly rent because your rent is guaranteed.
Let me ask you,
your rent is going to be paid, and oftentimes, it's paid by another entity. So the person who has the housing choice voucher is not making the payment, and we know that those payments are timely made.
So this is actually a related question that we've gotten since we've been doing the webinar. One of our live questions, is it mandatory for landlords to accept Section 8 vouchers?
That's a great question. In the District of Columbia, it is.
So it depends on your state
of California. It is, right, exactly. In Connecticut, it is. So it depends on your state or your local ordinance, because there are cities who are passing laws. I think Seattle might have just passed one.
So this gets to the issue of whether source of income is a protected class or not, right?
Exactly. Got it. Exactly. Now, there might be other instances, and it's specific, it's instance specific, but there might be other instances where the denial of the housing choice voucher might be a violation of federal law.
Interesting. Okay, so that, and again, that really depends on just like your local ordinances, and really,
or the landlord's policies and practice.
Okay, another good reason why our listeners need to talk to outside counsel.
Exactly.
Because there's just so many complications and nuances when it comes to fair housing.
Exactly.
So one of our other live questions that we got is giving data about the racial makeup of the community count as steering? So we spend a little bit of time on steering and advertising. So if you were giving data about what the racial makeup of that community looks like, would that be considered steering?
I would say yes. I mean, why are you giving the information? What's your purpose in giving the information about the racial composition of the neighborhood?
So it really goes back to asking those questions that we talked about in our first example. It's like, what's your real objective? And maybe there's a different way to do it, or maybe they have an objective. I can't think of the objective right now, but maybe there's an objective for that. But it's really asking those intentional.
I've been doing fair housing work for almost 40 years.
Yeah.
I cannot think of one reason why a landlord would be giving out race and national origin information about a neighborhood or a community. I am saying, do not do it. I'm not an attorney. I'm not your legal counsel, but I'm telling you, don't do it.
Got it. Okay.
This is Morgan. A related question which is a difficult question that a landlord may get, is what kinds of people live here? And NAPA, in our trainings for housing providers and others, a focus on that question and assess what would be an appropriate kind of response to the question, what kinds of people live here, from a fair housing perspective. Mm-hmm. And there's a number of ways to possibly answer that in a way that we think would be appropriate and responsive. And I'll just sort of list those off here. One is, we welcome anyone who meets our qualifying standards. A second is, we really don't keep those kinds of statistics, but everyone qualifies the same way to live here. A third is, we have a diverse community of residents with many different backgrounds. And a fourth would be, it's actually against the law to answer that question.
So options for our listeners. Okay. So another question that we had gotten prior to the webinar is, can you limit the number of occupants on a property? An example is in a 3-bedroom house, can you say no more than 4 people?
So, again, you want to know what your local occupancy standards say, and you're going to be guided by those local occupancy standards. A general rule of thumb is 2 people per bedroom or 2 people per bedroom plus 1. Mm-hmm. But your local occupancy guidelines are really going to rule the day.
And when it comes to those occupancy standards, recognizing that the local occupancy standards are what matters, is there a distinction between adults and children?
In some of them there are.
In some of them
there are. And also, the Fair Housing Act is, if someone files a fair housing claim, the trier of fact, or the judge, or the Department of Housing and Urban Development, or the Department of Justice, they're going to look at what is reasonable. So let's say that you've got a mom and a dad living in a 1-bedroom apartment, and mom is pregnant. Mm-hmm. Is it reasonable to go to mom and dad and say, you guys have to move to a 2-bedroom apartment because mom is now pregnant? Mm-hmm. Probably not reasonable. Yep. Is it reasonable, welcoming that new infant into the household to demand that they live in a 2-bedroom apartment? Probably not reasonable, right? So some of this is situational.
Got it.
And I admit that, but as a landlord, you do have to ask and beg the question, what is reasonable and what is unreasonable?
Got it. Got it. That's great. So I have two questions that I have, but I know that Maria is going through some of the live questions. There may be more, but these are the last two questions that I have. One.
Right before you go, Raquel.
Yeah.
So I know we're running just a few minutes over, an hour long, but I wanted to let everyone know that this webinar will be recorded and sent to everyone who registered. And in addition, you can download the slides because there was so much good information on these slides under our event content resources on your webinar page. So we're going to go with just a few more questions from Raquel. And if you can't stay, we totally understand, but don't worry, you'll get a link to the presentation in just a few hours.
Great. Thanks so much, Maria. So these are the last two questions. The first one is, let's say a developer is building 10 buildings, with 4 of them set aside for seniors. Let me rephrase that, is building a 10-unit building with 4 of them set aside for seniors. How would they market these apartments as a multifamily property management company while staying compliant with the Fair Housing Act? So 4 are set aside for seniors, and they want to be able to market for the seniors, but how do they do that?
Okay. So the Fair Housing Act has 2 qualifications for senior housing. One is 62 and older housing. That one is simple. Every single person in the unit has to be 62 and older. And the reason this person is asking this is because with senior housing, there is an exemption. You can exclude families with children if the housing is designed and designated explicitly and expressly for senior persons or older persons, right? So one designation is 62 and over. That's simple. Everybody in the unit has to be 62 or over.
Yeah.
Right? The other designation, and this is where it gets hairy, is 55 and over. If it is 55 and over, only one person in each unit has to be 55 and over. And in that situation, you can set aside a small number of units for people who don't meet the 55 and over qualification. This is a very, I wouldn't say it's highly complex, but this is an area where you definitely want to hire a fair housing attorney to help you and make sure that you're not running afoul of the law. The one thing that the law does say, however, is that you have to advertise your complex as a senior housing complex.
Got it.
So you have to advertise the entire complex
that way
as a complex that is designed for
seniors,
for older persons. Exactly.
Interesting. So the last question we have is, are landlords permitted to ask the immigration status of a potential tenant?
Why?
I mean, I guess that's my first question, yeah.
Is why. So as a landlord, when you go and meet with your counsel and say, I want to do this, I want to do that, the first thing your attorney is going to say is, why do you want to do it? You must be honest and truthful about why you want to do it. If your underlying reason for doing it has anything to do with something that is discriminatory, under the Fair Housing Act, you're not going to be able to do it. Now, let's say that you want to make sure that anybody who is living in your unit is going to pay the rent, they're not going to skip out, and you won't be able to find them, etc. That's fine. What that means is that the policies and procedures that you've put in place should make that determination for every single person who's renting your unit.
Interesting. Got it.
So if you have to ask if a person is a U.S. citizen or if they're an immigrant,
undocumented or otherwise.
Undocumented or other. What that tells me is you have the wrong policies and procedures in place.
Got it. Well, this has been so great. Thank you so much, Lisa. Thank you so much, Morgan. And for the listeners who are still with us, thank you for staying with us for a little bit over an hour. There was so much information that we provided. And as Maria said, all this information will be sent to those who registered and will be put up on YouTube and be able to be downloadable for the slide deck. But again, thank you so much to the National Fair Housing Alliance for being a great partner
Thank you for having us.
making sure that our landlords and property managers know a little bit more about fair housing than maybe they did before
I hope they did. I hope so. And please visit our website for more information.
Absolutely. So with that, we'll end the webinar. Thanks, everyone.
Thank you so much, Raquel.